Morning all. Am I audible?
Yes, sir.
Hello. Audible or no? Am I audible?
Yes, sir, Kaka, sir.
Yes, sir.
Hello. Safi sir,
Yes, sir.
am I audible?
Yes, yes, definitely. You are audible.
I think the slide is visible also. Yeah. So I'm request for apology. I regret I'm late, but there was an unexpected contingency. That's the reason why I had to, I had to go out and just rest back. I'm sorry for that. Unconditional apology. Now, what we were discussing in intellectual property was copyright. And in copyright, the specific area we were discussing was rights of copyright owner. And we said and we understood, we know that there are two kinds of rights available to copyright owner. Those are economic rights, and another one is author's special rights or moral rights. And in this, economic rights are discussed under section 14 of the copyright law, which we almost completed our discussion on. These were the slides we went through. As we already shared, there are as many as these rights which are available on the screen. The last right we discussed in the last class was adaptation, and we have just one more right to go. And that is what we are going to start with today, and then we'll move to other kinds of rights. And these were some of the important slides we discussed. I hope this will be useful to refresh our memory and just to have the continuity. This could be a good recap without speaking much. The idea of substantial copying and all those cases, starting there versus Leo Bernard India Private Limited, and distribution right, and all these. I hope this will be fine for us to be in the same boat and go forward with the discussion. This was the last slide before we broke for the last discussion. It's an important case, R.G. Anand versus Deluxe Phillips, wherein adaptation right was the issue, and we knew that in this particular case, in the case of adaptation, as the original work and the alleged infringing work are in different medium. One is a drama, another one is a film. So in that situation, when the works involved are of different medium, how are you going to decide the question of infringement? That was the issue there. And the principle laid down by the Supreme Court way back in 1970s, that is on the screen. And Ms. Suparna and very many others were very active with the discussion. And the one of the you can say the last right, which is available to a copyright owner, is with regarding importation right. Now the question is, What do you mean by importation right? That is, only the copyright owner will be entitled or will be will be entitled to allow or permit others to import their copyrighted work to any jurisdiction including India. So if somebody wants to what do you call export, or rather from perhaps from Singapore, if it is with Singapore, if somebody wants to export the books to Singapore, an Indian author's book in Singapore, then as far as people there is concerned, it is importing, right? From here it's export, and then from there it's import. Or if somebody wants to import these books from another jurisdiction to India, then that's an exclusive privilege of the copyright owner, and it can be done only with the permission of the copyright owner. But in order to understand the real commercial meaning of this, unless we understand that, it may not make much sense. So if you go to some of the celebrated books, some Oxford or Cambridge publications, if you are a lover of book, you would go to the from the content page and all those, the early pages, the cover page, and things like that. And you will definitely find that in many of the books you would find that it will be written, this is for sale. It is in the case of foreign books, usually you find this. This is for sale in India, Nepal, Bhutan, Bangladesh, and Pakistan only. Why is it so? Why is it so? If we ask that question, the international trade happens in a particular way. Let's understand that. Many times, the same book with same content of the same author, everything is the same, but perhaps the paper quality is different. One will be paperback, another will be hardbound. That's the only difference, but content-wise, there won't be any change. Perhaps even the cover page and cover design, everything will be the same. But these books will be priced differently in different jurisdictions. A book which is priced $100, perhaps that will be just 1,000 rupees in India. If it is $100, you can just multiply it with 75. So that is so much in America. It costs so much in America. But in India, if you are selling a book for 75,000, you all know the reality that there won't be much takers for that. Maybe considering that, there will be differential pricing, which I want all of you to you might already know it, differential pricing. Maybe considering the it has not much to do with the cost involved in printing and publishing the book, because to print and publish a book, each copy will never cost a person, an author or a publisher, 25,000 or 75,000. It is the author's the quality of the work. It is the status of author in the reader's world. All those will matter. Which publication does it publish it? All those will matter. And the publishing is the pricing is a very strategic decision. So as it is not that the cost related pricing that is happening, in India, they will give the same book for a very different price, perhaps for 1,000 rupees, which is a very meager amount when it's compared to 25,000 or 75,000. So what happens in this particular case? I invite your attention to this particular case: Penguin Books versus India Book Distributors. This is a High Court decision, wherein what happened was, certain books which were sold for a lower price in Africa. I'm just giving an example. This is the facts were almost like this. A book which is sold for 25,000 in US, perhaps it will be sold in India for rupees 1,000, and it may be available in an African country, in a poor African country, perhaps for 250 rupees. So what an intelligent a publisher in India can do is he can have 5,000 books purchased in Africa for rupees 250 rupees, the mere 250 rupees. He can import that to India, and only importation will cost extra, and perhaps distribution also. Whatever it be, the Indian publisher who bought the book from the African jurisdiction, well, the book is available for meager 250 rupees, will be able to sell it in India for 500 rupees. Now think of the situation. The Penguin Books, the original publisher, which permitted that to be sold, the book to be sold in America for 25,000 rupees, in India for 1,000 rupees, in Africa for 250 rupees. What is his position? Is the importation going to affect Indian publisher or US publisher if he's importing that or exporting that to US also? So for 25,000, a customer gets the book in US. In India, it is for 1,000 rupees, but the person is going to sell it for 500 rupees as he is getting it for 250 rupees in Africa. What is going to be the plight of the publisher in US and publisher in India? And please note, the speciality with the situation is this. This is an original authorized copy in Africa. Is this going to affect the commercial interest of the publisher in India and America? That's a question we should be asking. And is it possible for the publisher in India and India and US, to stop the second publisher from purchasing the book from Africa for the meager sum of amount and sell it in India and sell it in America? Is that possible? Is that allowed? It is not a legal question as such. It's a 100% commercial question, because this is a commercial interest which has been recognized and protected by law. That's the definition of law, right? So, what do you think? Can this be allowed? Should that be allowed? It's a policy question, in fact. What is your take on that? Ms. Ashwati, what do you think about it? Ms. Pooja Mole or somebody who can respond to this. Of course, I know that you are not just undergraduate students, but I definitely can try to know your view on this. I hope the facts are clear, the situation is clear, the commercial interests that are involved is also clear. If that be so, then what would be your take on this? Anybody? I expect an answer. Can the second publisher be stopped by the first publisher? That's a question. Yes or no? Can I have that? Safi sir, am I audible? Am I not audible? Mr. Akhil?
Audible, sir.
Yeah. Please. Then it will be better. I'll be happy if it's audible. There is a response for that. So, what do you think about this question? This is an important thing as far as intellectual property is concerned. Mr. Akhil R. I suppose that is your name. If you can just respond to that, that'll be a lively thing.
Sir, actually, I think infringement of first party.
But this is an original authorized copy in Africa. Now, from the customer's point of view, people like you and me, the Daridra Narayanas of, we may not be so much, but we have a lot of Daridra Narayanas in India. So from the point of view of customers,
we get a reasonable price from Africa. In the modern time, we will purchase from online market. There will be also Indian publishers' rights will be infringed.
So are you able to purchase it? You just try it in Amazon. Are you able to purchase that for African price? Just try it. There you understand the politics and economics of copyright. Just try it. No, this is, see, when it comes to a world famous book of J.K. Rowling, for example, you know which book that is. The Magic. J.K. Rowling has published which book?
Harry Potter series.
Harry Potter. Thank you, Anisha, for that. Harry Potter. So when it comes to Harry Potter, which is a world well-known book, famous book, which has got a world, all the world, pan world, I can say, pan world appeal and market. This matters. And what should have been the stand taken by the court? The Indian court, to me at least, should have taken the stand that as it is an authorized copy in Africa, then importation in India, there is no provision in law expressly stating, or law is, you can say it's silent about this. It doesn't say, because court could have definitely interpreted it by saying that as it is an authorized copy in Africa, and buying and selling it in India is also authorized. It is not an infringement. Could have been said, because there is nothing in, if you read copyright law through from cover to cover, you won't find anything. Only possibility is a possibility of interpretation, and whether that possibility of interpretation was done by, no, you may have to remember about your judicial process, wherein a policy question also will have to be addressed by the judges. So if he was concerned about the Indian customer and the Indian policy from the Indian customer's point of view, the developing country perspective, the judge could have given, it would have been fully, even TRIPS agreement or none of the WTO agreement is clear on this. There was heated discussion on this, but there could not be any, consensus on that. This ultimately, what happened is the Indian court has given a judgment by saying that is an infringement. By what's happening, by saying that what is happening actually, the Indian customers who could have got the book for 500 rupees instead of 1,000 rupees, that is effectively prevented. That should not have been the policy for India. But anyway, we are not to understand all those importing of books meant for a different country while it's importation right. And importation right is a very hotly contested, very hotly discussed topic during the WTO discussions, the GATT discussions. So that is the impact of this. This is how it has been interpreted in India. Now you can have your own take on that. I gave the background of that, the implications of that. Now that's about the case. I hope the thing is clear. Miss Anisha, is that clear?
Yes, sir.
Okay, thank you so much. Now we are completing with that. We are completing the discussion on economic rights. We have a sense of all the economic rights now, which are discussed under section 14 of copyright law. Now we are moving to the second club of rights, second set of rights, which are known as other special rights, or otherwise popularly known as moral rights. It is discussed under section 57 of copyright law. Now, as I said in the earlier class, other special right or the moral right is more concerned about, it is concerned about the personal relationship the author has with the copyrighted work. Because at least theoretically or in reality also, a book is the brainchild, a creation of the author. So he wanted that particular work to be created and remained in a particular way. Another person could have done it better, but the author, it is author's effort and author's brainchild, and author wanted his child to be in a particular fashion. That integrity of the work is to be respected, is to be, what you call it, is to be recognized and protected. And there is also another right, because this is his brainchild. So he should be able to say, I am the father of this, I'm the author of this. So there are certain rights which has got nothing much to do with economics, but which has got much to do with the personal relationship the author has with the work. So these rights are known as author's special rights. Please do make a distinction between owner's rights and author's rights. These are the rights available to the author, need not be the owner. Take for example, Randam Uram, a Malayalam celebrated book, or God of Small Things, a Booker Prizing Indian novel, authored by none other than Arundhati Roy. So Arundhati Roy has transferred her economic rights under Section 14 to Penguin Books. So nevertheless, the rights under 57 will be available to the author, and please note, not to the owner, to the author only. It is not available to Penguin Books. It is available to Arundhati Roy only. This is author's special rights. In reality, in industry, in very rarest of rare cases that you find an author is publishing himself or herself. It is the publisher and the author is only a royalty taker. Author is not much interested in this, all this organizing and this industry related things. He's not interested in it. He's or she is interested only in writing or composing music or in creation. So he'll be interested to have some, so what do you call, have some return for his living. That's all. So, but what happens here is, what is notable, what is important here is, this is author's right and it is not owner's right. These rights are available to the author even after the transfer of economic rights under Section 14 to another publisher, to another person. Is that point clear, Mr. Akhil?
Yes, sir. Yes, sir.
Yeah, thank you. Thank you for the response. Advocate Reshma, I think I'm making things clear.
Yes, sir. It's
So with that background, let's understand what are the rights that those are recognized. So what is a right to claim authorship? To put in simple words, even after the transfer of copyright, God of Small Things should be known in the name of Arundhati Roy herself, even though economic rights are transferred. The publisher, Penguin Books, cannot say, as the rights are transferred to us, we are not going to mention Arundhati Roy here. That cannot be said, and if that is said, Arundhati Roy can claim, invoke, right under Section 57, which says that even after the transfer of economic rights under Section 14, these rights can be claimed. Now, is that all? No, there are other rights as well. The second right, available under Section 57, which is available to the author and author only, even after the transfer of the rights to other owners, is right against distortion, mutilation, modification, etc., which would affect the reputation or honor of the author. So, if the owner of the copyright, the publisher, after the transfer of the copyright to him or her, Penguin Books, for example, Penguin Books is making certain changes like distortion or mutilation or modification, which would affect the reputation or honor of the author. So he wanted the work or she wanted the work, the God of Small Things in a particular way. J.K. Rowling wanted her work of Harry Potter in a particular way. But the publisher is changing it, perhaps because that will have more market, a better market. He can sell it better. If he's adapting that into cinema, some of the climaxes can be changed. If it is a cinematograph film, if climax is more dramatic, and there will be a better market for that. It will be a box office hit. Now let us consider that situation. Now what happens is, this right can be understood in short as right to integrity. So there are two rights. The first right is right to claim ownership. The second right is right to integrity. The work to remain as it was created by the author. This is available even after the transfer of other rights, and it is not available to owner. Kindly note. Now, in this respect, there is a case which is important. Perhaps there are one or two cases only. There are very few cases in this area in India, and let us consider one of the cases. The case is Manu Bhandari versus Kala Vikas Picture Limited. Kala Vikas Picture Limited. The facts are like this. Manu Bhandari is a celebrated author who has a good readership, who commands a good readership. So what happens is Kala Vikas Picture Limited, a film producer, which is indicated from the very name of the producer herself or producer itself. So what they did is they obtained the right to make cinematograph film, one of the adaptation rights, one of the rights available to author under section honor under section 14 of copyright law. So copyright, all the rights with regard to this is obtained by Kala Vikas Picture Limited. Now, a cinematograph film is not just a literary work. It has got a lot of investment into it, a lot of technicalities into it. So it's a combination of very many things. They have to take care of the market. Author can just have the imagination and she can write whatever she wants. But a producer is concerned about the return. He is more a producer, a commercial person, perhaps than a literary person. So what they did is they incorporated certain songs, which are the requirement of a cinema. They also incorporated certain fight scenes, I appear, or rather you can say they incorporated certain commercial masala, which is a requirement of the film world. So Miss or Mrs. Manu Bhandari came to know about it. She must have objected to that. Perhaps the which form I do not know. Perhaps she might have got a letter, a notice issued by a lawyer. But these people, Kala Vikas Picture, they did not yield to that. Ultimately, she filed a case before the High Court. And the main contention by the Kala Vikas Picture against Manu Bhandari was this: we are the owners of copyright, and we can decide the way in which it should reach the audience because all the rights are vested with us and we have already paid her. But the court had a different take because section 57 has a different tone and a tenor. Now, what the court said was, this author's rights are available in spite of the transfer of the economic rights, which are known as copyright. These are special rights or moral rights. And as Manu Bhandari has moral rights, she is very much entitled to be, to insist that her novel is to be adapted as a film the way she wanted that to be, the way she wrote it down. So ultimately what happens is you don't have a judgment. There was a, what you call a compromise, and the judgment was passed by the, in terms of the compromise. Anyway, perhaps this is one of the earliest of cases in India wherein moral rights were recognized, and this is one of the instances. The other people, the film people, came up with a compromise proposal just because they understood that they are going to be on a slippery ground because the person has a right under section 57, the copyright law. Would that be all right? Can I have a yes or no? If it is not no, if it is not yes, I can add to it. I can add to the. It's
Sir,
yes,
in
right?
this case,
Yeah.
the compromise was considered, no particular decision.
The decision was passed, but that was a compromise decision. But the compromise, the film people were not yielding. They were not yielding to her request. They decided to yield to the request just because the court took a preliminary stand that they can be stopped. Had it been otherwise, had it been that this right cannot be recognized, they should not have. They will not have come for a compromise, right? So this is an
Yes, sir.
instance where a right was recognized.
Okay, sir. Thank you.
Okay, that's the importance of this case, though it was compromise. The compromise happened just because the right is recognized, in spite of transfer of copyright. Okay, let's move on. There is another case. I don't want to spend much time on this. This is a case where the similar things happened. But here the case, this case has widened the scope of section 57. Here, what was in issue was a bronze mural. It was donated by the owner, Amarnath Sehgal, to Vijnan Bhavan, a museum. But as you know, in government museums, they may not, I don't want to blame it, completely, but it may not be maintained very properly. It can happen. So in this instance, non-maintenance by government, and it was almost in a dilapidated condition, or it was almost destructed. And when Amarnath Sehgal, the creator of that, I don't want to use the word author, creator of that, he really felt bad, and he argued by way of a case that there is loss of honor and there is mental injury. The court accepted it. The importance of this is this: it just made the scope of section 57 very wide. It's applicable to in extreme cases like this. It is not an instance where there is something done to modify it. This is in a way, this is mutilated, you can say. So integrity is lost. They never they never objected to the authorship of this. So this has widened the scope of the right, and the court said this right can be recognized, and this right under section 57 is significant in Indian jurisdiction also. That's the significance of that case. With that, we are concluding the discussion on section 57, that is author special right. The two main rights are the right to claim authorship and also right to integrity. And there are main two cases: Manu Bhandari versus Kalavikas Pictures, which can be asked even as a objective type question. And there could be another case, Amarnath Sehgal versus Union of India, wherein the scope of the right is widened. And though I did not mention it earlier, there is another right also which requires some sort of mention. This is a right which was not originally there in the copyright law, but was later incorporated under section 53, capital A of Copyright Act 1957. The right is, as you can see on the screen, the right is right to claim resale share in the original copies. Just think about the situation where somebody who is interested, perhaps like the superstar Mohanlal, or anybody who likes the original things or old things. There is value in old things, right? There are people who make use of that as well. Now, if somebody is interested in one of the books of Arundhati Roy, the same example, and if the person is interested to have the original manuscript of it, the original thing which was written by her hand by Arundhati Roy herself, or think about the plight of the author of an artistic work, a painting, which was sold by the original owner to the first buyer for a peanut price, for a peanut price, because he was not or she was not very famous at that point of time. Later on, she or he might have become so famous, and the resale of that might happen for lakhs and crores. So there could be situations like this, right, where you got the original author got peanuts for the original thing, and later when the author is on the streets, beside the street, without anything, even not even a beedi to smoke, if he's on this street, and his works, his creations are being sold for lakhs and crores, he doesn't get anything for that. This right is recognized later on in the copyright law to take care of this situation of the authors. Let us read that. It goes like this: author of original copy of painting, sculpture, drawing, manuscript of literary, dramatic, or musical work. in spite of the transfer, even though all the rights under section 14 are transferred. If there is a resale value, and if the resale value is more than 10,000 rupees, he is entitled to a share in the resale value. She is entitled to, or he is entitled to, a share in the resale value if it is sold for 10 crore rupees. A resale value which shall not exceed, a limit is put, but there is something available to the other, which shall not exceed 10% of the resale value. If it is for 10 crore rupees, it cannot exceed 1 crore, but it can go up to 1 crore. Something is better than nothing. So this right is available as a right like other special rights under section 57, which is available in spite of the transfer of the copyright under section section 14. And the purpose, which you may not get fully if you read section only. The background I gave, and this is the reason why this right is recognized. And what happens is this: and if there is a dispute with regard to the percentage of the value that author should be available with, author should be entitled to, which cannot exceed 10%, but it could be 1% also, it could be 10%. So there could be a dispute. And if there is a dispute, Copyright Board is authority which can decide it. Would that be all right? Ms. Pooja, is that clear?
Yes, sir. Yes, sir. It's clear. It's clear.
Thank you. Thank you. Thank you, Ashwati Ramachandran, for responding. I hope it's clear to Aparna also. It's Aparna. Now, let's move to transfer. Transfer of copyright. We are done with the rights. Rights available are copyright or economic rights, other special rights or moral rights, and right to claim resale value in the original manuscripts or original works in the resale. Okay, those are the three rights, and that's a major area. There could be many questions, from in the intellectual property paper from that particular area. Now, with that, let's move on. The area we are moving on to is transfer of copyright. Transfer of copyright. Like any other right, copyright also can be transferred. It is the case with all the intellectual property rights except geographical indication, which you may note. That could be a good objective type question. Transfer is recognized in all the cases of intellectual property rights except geographical indications, which cannot be transferred. The transfer of which is prohibited under the law, under the geographical indication law. That's important. That could be an important point. So how can it be transferred? If it can be transferred, or rather, transfer is the very heart of it, because it was not the author who made hue and cry for recognizing copyright. If you go to the history of it, I think, which we discussed earlier. In fact, those were the publishers. And publishers wanted the rights to be recognized for the author because they wanted to make use of it. They wanted to get it transferred. So transfer is an essential commercial requirement, business requirement of copyright law, like any other intellectual property law, intellectual property right. So copyright also can be transferred. We know very many instances. And in most of the cases, it is not the author who publish it. It is only the publisher who will publish, another publisher, a commercial business house that will publish it. So there can be two kinds of transfer possible. There can be, there are two kinds of transfer recognized under copyright law. The first one is assignment. Another one is licensing. Now, what is assignment? Assignment is nothing but, generally, my understanding goes like this. I think Safi sir also, and you people also would agree with that. Assignment is nothing but transfer of intangible property. An intangible right is transferred. The word we use is not transfer as such. We will use another terminology, that is assignment. That's my understanding, and I think that's right as well. And that is a complete transfer of ownership. Proprietary interest is being transferred. The ownership is being transferred. That is what assignment is. There is another kind of transfer which is recognized under copyright law, and it is known as licensing. But carefully, I will make a statement that even though we put it in the basket of transfer, in fact, in reality, this is not a transfer. Legally, also, it is not a transfer of copyright. It's only permission, in fact. We might have learned the difference between lease and license when it comes to Transfer of Property Act and Easement Act and that paper. That's my understanding. Usually, it comes as a subsidiary subject in the paper related to transfer of property. So one of the major differences, the core difference, legal difference, as far as the differentiation of these two kinds of transfers is this. In the case of assignment, it's a full-fledged transfer where there is transfer of proprietary right, transfer of ownership, wherein in the case of license, there is nothing is transferred, but there is only a license. There's only a permission to use the same work. So that makes a lot of difference when it comes to the reality. And assignment holder becomes the owner. He can file a suit for infringement himself, but a licensee cannot. License could take different forms, which we may not get into. It could be exclusive license, wherein even the owner of copyright cannot stop him. He will have right even against the owner of copyright, maybe for 1 year or 5 years or whatever it is. Now let's go to the, with that background, let's go to the concerned section. Section 22 of the copyright law deals with that. And it reads like this. I request all the respected participants to read this. The owner of copyright in an existing work, I underline, I boldened it. I wanted all of you to note it. Existing work or the prospective owner of the copyright in a future work. Prospective owner of a future work may assign to any person the copyright either wholly or partly, and either generally or subject to limitations, and either for the whole term of the copyright or any part. Can you just go through it once again, please? It may not be allowed. Mr. Akhil, would you mind reading that out for us? So that all others will also be there with us. Would you mind doing it? Are you there? Or somebody else? Yeah.
Sir, may I?
Yeah, please, sir. Thank you.
The owner of the copyright in an existing work or the prospective owner of the copyright in a future work may assign to any person the copyright either wholly or partly and either generally or subject to limitations and either for the whole term of the copyright or any part.
Thank you for reading out at a very appropriate pace, because it was not just reading out that mattered. It was, the reading in a way others will, take that in. Thank you for that.
Thank you, sir.
Okay. So the right is available to the owner of copyright. If it is an original creation, just after the creation, the copyright goes to the author, unless it is an employed author or a special kind of situation, which we discussed under section 17 of the copyright law. So it can be author or owner of a copyright in the existing work, which is already created, which is available, or considering the need of the industry, business industry, including film industry and drama industry and very, very many other people in the industry, copyright law, because the right is nothing but an interest recognized and protected by law, and the requirement of the market in the copyright market for the copyright work should be taken into consideration before structuring that right. So you can really see that the requirements of the market is really taken care of. That's the reason why it has become so liberal and flexible. Anything is possible. So let us read that once again with that understanding. The owner of the copyright in an existing work or the prospective owner of the copyright in a future work. Many times, the producer of a film may employ or will have an agreement with the playwright to write a book which can be made into a film, or for making a screenplay. So that will be made in future. Or there could be a situation where, now just think for a moment, Hrithik Roshan, the iconic actor, Hrithik Roshan, decides to write his autobiography. Would there be takers for that? Would there be a good market for that, at least in India? Definitely yes, right? Goes without saying. So, from the very moment Hrithik Roshan decides it, there will be a queue of publishers in front of his house, because they know that it is going to have great market, at least in India, perhaps outside India as well. So that is the requirement of the industry. So what they will do is they will come and have, the author can really bargain with the people. So that is the reason why it is it is structured so. The owner of the copyright in the existing work or the prospective owner in the future work may assign to any person, including including publisher or anybody, the copyright, either for wholly or partially. What is the understanding of this? It could be all the rights recognized for that particular work under section 14, or it could be some of the rights, or it could be even division of the same right. It's quite possible that there could be two publishers for the same right. See, if it is a book, if it is a celebrated author who can really bargain, you can very well say that I'm giving this right to two publishers. So even division of right is possible. So wholly or partially would mean whole of the right or some of the rights, or it could also mean even division of rights. So I think that you really understand the how it fits into, or how it takes care of the market situation, and either generally or subject to limitation. They can say that only in South India, only in North India, only for 5 years, or it could be any condition. You can say that there will be 3 publishers, or you can say that you can sell it only for this value. So any kind of limitation. So generally, you can say it without any conditions, no frills attached, or it could be with so many conditions. It's quite possible. You can say that only in India, and that's how many of the publishers are making use of this, saying that it can be sold only in India, only in the Indian jurisdiction, or in India, Nepal, Bangladesh, and Pakistan, where you have similar set of people. Purchasing power is almost the same. So many kind of limitations are possible, or it could be generally allowed. And either for the whole term of the copyright, it could be either for the author's right plus 60 years, which is the whole term of copyright, or as per the second rule, it could be 60 years from the date of publication, in the case of cinema, the case of photograph, and things like that. So it could be for the whole term of the copyright, or it could be for 5 years, for 10 years, or it could be anything of that sort. So all the possibilities are recognized. Or it could be as good as saying that you can do almost anything with your rights. You are the Sultan, you are the Raja with your right. But in reality, is this happening? Unless you are an established author. Many times you may have to pay the publisher for publishing it. That's a reality. That is part. And for this, you may have to have a written agreement signed by the party or by the authorized agent. Those are the other requirements. So this is how the assignment transfer is recognized under copyright law. And kindly note that this is recognized considering the requirements of the market, mainly the requirements of the publisher. He can get any kind of right or in any manner for any duration with he exclusive right or with others or in any fashion. So it's very liberally constructed. It's couched in a way which is so appropriate for the requirements of the industry. So license is discussed under section 30 of copyright law. And if you substitute the word license, which is in the third line here on the screen, with assignment, all other things are the same, almost the same. So license is also similar. It's also very widely worded, very liberally. It can be liberally constructed, considering the realities of industry. Now, there is another concept called compulsory licensing. I may not go much deep into it, but it will be worth if I mention it. Compulsory licensing is also a situation where the work is being licensed, it is being transferred in a way, subject to what I said earlier. Licensing could be two kinds mainly. Licensing could be either voluntary license, wherein if I am the author, I get an offer. We know the basics of contract law. I will negotiate with. The offer will be accepted by me. There will be an acceptance and things like that. Consensus addendum should be there. Then free consent should be there. All the requirements for the contract law will have to be complied with. And if I'm entering into a contract, as we saw in the last section, section 22, either partially or for a whole period or all the rights or some of the rights or for 5 years or for the whole of the term or only in India or only in South India or something like that. It could be, it's very flexible. So, but all this is done voluntarily. There is consensus addendum. There is an agreement between, there is a meeting of mind as far as terms of the contract is concerned between the publisher and the author or the owner. But there are situations where the author or the owner is compelled to transfer his or her right. In fact, this could be a violation of some of his fundamental right in a way we can think of that apart. But copyright law, like patent law, where it is much contested area, in copyright law also it's a contested area where it really matters. So here what happens is a person is compelled, he's not ready to license it voluntarily. The owner is not ready to license the work voluntarily. The person is compelled to license, to give permission to publish his work to another person. Is that allowed? Can that be allowed? Isn't it arbitrary? On the face of it, prima facie, that could be the impression you may create in your mind yourself. But that may not be so. There are certain special kind of situations, and only in those special kind of situations this can be done. And the consent provisions are section 31 to 32 BA. There are a few provisions there. I'm not going deep into it. But there are certain conditions, and only it can be done only if those conditions are complied with, and it can be done only by a government authority. And there could be sufficient reasons. There should be the reasons or the situations that are required under copyright law should be proved. Then only compulsory license can be compulsory license can be granted. Now, the conditions are like this. The first one is it should be a published work. I'm an author, I've written a book, and I've kept it inside my drawer. Here, I've got a drawer. I'm not publishing it. You cannot be compelled to publish it. If you have already published it, then that is one of the conditions you are complying with. The person has complied with. So it should be a published work. And now that work is withheld from the public. There could be very many examples. So if you look for, if you're a researcher, many of you are. As teachers also we are researchers. Many times if you are very seriously doing it, you may have to go to some of the historical works, very old books, which may not be in print now. Out of print, you would get the answer. Even Amazon would say that, even the original publisher or any bookstall will tell you, this is out of print, sir. This is out of print, ma'am. That will be the answer you will get. So in that situation, you can say that work is withheld from the public. And the right you can get is to produce and publish. Produce in sense, print and publish. And you can also get the right to print and publish the translation. Print and publish the translation. Many times what happens is if it is available only in English, which is not at all in Indian language. This is not recognized as an official language in Indian constitution also. You know, Schedule 8 of the constitution, wherein 22 languages are recognized as official languages, and English is not in the list. So there may be a situation where you may have to translate that into Hindi or Tamil or Malayalam or whatever it is. So that will the students there or the researchers there would require it, but this person is not coming forward to translate it. So these are some of the circumstances wherein you will it will be a proper ground for applying for compulsory licensing, and compulsory licensing can be granted by copyright board, and the person who may be doing it may be the registrar. Now it is under a different registry. You have some changes in the controller. That's the name now. They use for the person, but almost everything else is the same. So the right will be granted. Compulsory licensing will be granted, even against the will and wish of the copyright owner, if these situations are present, to reproduce and publish work for certain purposes, perhaps only as a textbook. Or it could be, there are situations where now presently it is recognized. Presently, it can be adapted for the purpose of making braille. Braille, you are aware, aren't you? In fact, one of my students here in Calicut Law College, she's in the 5-year course, first semester now. She is, she in a way, she's blind. I would say, I'm sorry to say that. She's differently able. She can't see it. And she came to me, in fact, somehow she reached me and she said, sir, I've got some problems. I don't have much materials. I've got some softwares in laptop, which will read that out, but it's not that very useful. And is there a way in which I can study better? So immediately the copyright law came to my mind. And one of the provisions which is added to this by way of an amendment later on, I'm just telling you, is this if it is being adapted for the purpose of people enabling people who are differently able, that's also a requirement. That's also an instance where compulsory license can be granted. So in the case of compulsory license, it is without the permission of the person, and a second person should apply for that. A second publisher should apply for that. A second person who is willing should be will apply for that. And the authority, copyright board, and the controller will have to consider the public interest involved in it, the need for that, all those the surrounding circumstances as required under these sections or which is available on screen will have to be considered. Ultimately, they will come to a decision. And even if it is a compulsory license, the second publisher who gets the permission to print and publish the work of the original publisher will have to pay a royalty. That royalty also will be fixed by the authority. So this is the situation. This is the idea of compulsory licensing. So this will be granted only in special circumstances. if the books are available and if the books are available for a reasonable price. Even non-availability of the work for reasonable price could also be a ground wherein it could be compulsory licensed. If it is very unreasonably priced, the book is so much required for a student and is available only for 10,000 rupees. And if another publisher comes forward to print and publish it for 150 rupees, definitely that could be one of the situations where it could be compulsory licensed. I'm just giving you an instance. So registrar now is controller, copyright board to decide terms and conditions, and the license could be terminated if there are circumstances in which they decided to give license doesn't exist. That can be done. That can be brought to the notice of the authority by the original publisher. The original condition doesn't exist, so it could be terminated. Royalties to be paid and things like that. I think I give you almost a reasonable idea about compulsory licensing. This is a case which I thought I'll just share with my privileged audience. The case is Super Cassette Industries versus Entertainment Network India Limited. Super Cassette Industries versus Entertainment Network India Limited. This is an instance where the scope of compulsory license is widened so much. Here it is, I think it is Red Chilies or that was involved. There's a radio channel, that FM, which is very famous. So they applied for compulsory license in the case of music. Many times our understanding is this, music may not be, is not much a necessity, an essential thing as far as people are concerned. Here, one of the publishers applied for compulsory license in the case of certain film music. And what the court found was this: compulsory license can be granted even in the case of film music. And it was in fact granted. So the scope of compulsory license has been made very wide by the court through this interpretation. So I just wanted to share those ideas also with you. So I think that is put across. Is that clear, Ms. Aparna?
Yes, sir.
Yeah, I think I have the permission to move on, right? Ms. Neetu? May I?
Yes, sir.
Yeah, thank you. I think it's clear, right? If it is not, please put that across. I'm duty bound to explain it with other examples and in different words. I can do that. I hope it's clear. Yeah. If the way we discussed, the way we traveled in copyright is like this. The question we addressed are, just have that logical order, that logical sequencing in mind. That's also important for a proper understanding. What we discussed was, what is copyright and the very purpose of copyright: to encourage, incentivize creation. Then what we discussed is, what are the subject matters of copyright? We have 6 subject matters of copyright, like literary work, artistic work, dramatic work, musical work, sound recording, and cinematograph film. It was under section 13. We made sense of that. Then we understood who is the owner of it. We also understood the situation where employed authors may not have authorship, will not have ownership, only authorship. We understood that position. Then we went to the basic principles of copyright law, like idea, expression, dichotomy. We also understood the originality and those requirements. What happened then? We discussed the rights. We have 3 sets of rights, like we have economic rights, we have special rights or moral rights, and we also have a very special right, that is right to claim a percentage of resale value under section 53 capital A of copyright law. Then what happened? Then we move to transfer. So first the basic principles, subject matter, ownership, then rights, then transfer of rights, now to infringement. That's the order in which we are moving on. You should have the whole picture in mind, itinerary in mind, so that we will have a better understanding. Where are we destined to? Need to have that understanding. I hope this 2 minutes will make more sense to our discussion. Now it is violation. Section 51 is important here. Section 51 is important here. What it says is, what it declares is this: copyright in a work shall be deemed to be infringed when any person does what? Does anything covered by exclusive rights. Under section 14, I'm adding it. That's how we should read it. So there are certain exclusive rights. If the rights are exclusive, then only he can do it or she can do it. Nobody else can do it. So if another second person or a third person does anything, which means he reproduces or makes translation or public performance or translation or importation or anything, or rental right in the case of films and things like that. So if another person does anything covered by the exclusive right under section 14 of the copyright law, then it's commonsensical for us to understand that it's an infringement. That common sense is declared in section 51 of the copyright law. So that goes without saying. It is my right and my right only, and if you are doing it, that's an infringement. So that's the very purpose, that's the very heart and soul of copyright law. You can stop others from doing it. So this makes copyright what it is, and this provision gives copyright its tooth. Unless there is enforceability, there is no possibility, and there is no much meaning in a right? So, but that's not all. That is the first set of infringement. There is another one, which the first one we can call this as primary infringement. The terminology has not been used in but usually we use it to be, if you use it, you understand it better. The decision is directly infringing or violating the exclusive rights of the copyright owner. I'll stop it. Perhaps I know that the time is running, but I'll take another 2 minutes or 2 to 3 minutes. That's all. This is another instance. Go to the second paragraph here, or the third paragraph. Okay. If another person permits, he's not doing it himself. That's a important point we may have to note. Another person permits with his knowledge for profit, in the sense he is getting something paid, any place to be used for the communication of the work to the public. Now what happens is, there is a broadcaster. He has got broadcasting facilities. He's not broadcasting himself, but he takes a lakh of rupees and he's allowing another person to broadcast a new film, Broadaddy, for example, a new film, from his using his broadcasting facility and place to the public. But he can definitely say that I'm not doing it. I'm not doing it myself, but with his permission, and when being paid, he's allowing another person to do it. So this is secondary infringement, as he's not doing it himself. We call it as secondary infringement, though, as I already said, the terminology is not used in the copyright law. There is another instance. So copyright in a work shall be deemed to be infringed when any person makes, sells, let for hire, distributes, or by way of trade displays exhibits to such an extent as to affect prejudicially the honor of the copyright law. Which means that a person who comes in train with an old looking bag, wherein he will have CDs without much names and things like that. He will say that new film CDs are available, sir. You can get it for 40 rupees. Outside it is 250 rupees for original. You can get it for 10 rupees, 20 rupees or 40 rupees. It is, you get to see it, right? A lot. So what happens is another person makes, sells or let for hire, distributes or by way of trade display exhibits to such an extent. So it is not necessary that the person should be doing all this himself, as it is required in the case of primary infringement. Any person who is supplementing it, who is helping this, who is an abettor to that, who is a conspirator, all these are some of the words I can use it to convey the idea in the literal sense. So a person does all these, who may not be doing it primarily himself, is also an infringement, and the second and third category of people are known as secondary infringers. And the last one, we will be stopping with this. imports in India any infringing copy of the work. So here the word used is, please note, I'll connect this to Penguin Books versus India Book Distributors, the case which we discussed with regard to importation right. So what is the, what really happens in the case of infringement? In the case of infringement, if a person imports in India any infringing copy of the work, but please note, this was an original work. Let's go back to, as a discussion, let us go back to that case. It was an original work in Africa. It was an authorized copy. And no person has a right. Once I sell it, I cannot control resale of it. That's against the basic principles of trade. Because there should be free trade available. It's a free trade law and free trade world. So I've already sold it. I'm the owner. I've sold it. And if that person sells to another person, I cannot stop it. How can I stop it? I don't have that right. But that is recognized by way of interpretation. That is where the policy comes in. Am I making sense, Mr. Akhil?
Yes, sir.
Yeah, making sense, right?
Yes, sir.
Yes, sir.
Yeah. So that the word infringing copy is not defined, and the court could have very well said that this is an authorized copy, and that could be the better thing for the people in India, and that could be the better thing. Like second sale is not within my right. If you read section 14 very carefully, I have got the right to control the first distribution. I cannot control rental. I cannot control resale. Nothing is possible. In spite of that, court has given this interpretation. Now that is the law in India. So infringing copy, as it is not defined, it could have been definitely interpreted by saying that anything which is authorized in another jurisdiction is authorized here as well. So there is no infringement under section 51. But the kind of interpretation given was something different. So I think that makes sense. And with this, we stop here. But it's not all. We'll go forward in the next possible day. And again, I would request Safi sir to make some time available to me. That would be humble request. And if you have anything to clarify in today's discussion, you can definitely do that. I'll try to do that to my level best. And that's it for the day. Once again, I'm sorry for make you wait for some time. Sorry for the delay. Yeah, that's it. Bye. Take care.
Yeah,
Thank you, sir.
Thank you, sir.
Thank you.
Thank you, sir.
Safi
Thank you
sir,
for the
thank you so
wonderful
much.
session, sir.
Hello, sir.
More-
Thank you very much. Thank you very much, sir. Thank you very
Thank you,
much.
sir.
Yeah, again, a
Thank you.
request
Thank you,
to
sir.
give me another class.
Sir, thank you very much. Thank you very much.
If possible, subject to your convenience.
Thank you so much, sir, for this wonderful session. To make it more interesting with the live case laws and examples. Thank you, sir.
Thank you. Thank you so much. So with your permission, I'll leave the class. Thank you so much. Safi sir, thank you.